Submitting his case before the CCJ on Wednesday in the matter of Irfan Ali and others versus Eslin David and others, attorney-at-law John Jeremie argued that the merit of the case before the court is whether the Court of Appeal actually had jurisdiction to rule in the matter which was brought before it.
Whether the Court of Appeal had jurisdiction to entertain the motion filed by Eslin David. And my answer to that, Your Honors, is that the Court of Appeal was exercising without doubt its powers under Section 177(4) of the Constitution of Guyana.
The attorney sought to establish that due process was followed by the appellants as well as the court, given that an interpretation was sought as to the meaning of more votes cast, as is provided for in Article 177(2)(b) of the Constitution. Attorney John Jeremie referenced a case brought before the Court of Appeal in 1980 featuring UC Guyana to support his argument.
The Guyanese Court of Appeal, acting as the final court in Guyana in 1980, says this: the issues that can be properly dealt with are the qualification of the president, that is the qualification of the president, or the interpretation of the Constitution. Lord, those words do not require any interpretation. Those words in the judgment, they are words of the final Court of Appeal in Guyana in 1980.
Attorney-at-law Justin Simon, in a joint representation of the Attorney General Basil Williams, also posited that the Court of Appeal had jurisdiction in the case that was brought before it. The attorney cited that the court can intervene in the process before a declaration is made as opposed to an election petition, which PPPC Attorney-at-law Douglas Mendez purported to be the correct means of questioning anomalies arising from the process. The attorney alluded to the case of Holland versus the returning officer as basis for this argument.
The case of Holland versus the returning officer during this whole election process in Guyana, there was no election petition which was filed. In that particular case, the returning officer fell ill. Somebody else was substituted, but the election officer could not validate or state very clearly that what the substitute had done was correct. And I believe it was my very learned friend who sought or in the intervention of the court in respect of this matter. So it was during the election process that this took place.
The attorneys-at-law to the case continued with their submissions until late Wednesday afternoon, after which the president of the CCJ, Justice Adrian Saunders, adjourned the court to Wednesday, July 8, at which time it will deliver its judgment. Reporting for AGP Nightly News, Wendell Badrie.